Welcome to the deep dive. We take your sources, unpack them, and pull out the key insights for you.
That's right.
And today, we're getting into negligence, specifically those first really critical parts, duty of care and breach of that duty.
We've got a pretty comprehensive source here. Unit 6 negligence, duty of care, and breach of duty. It'll be our main guide.
Okay.
And our mission, really, is for you to finish this with a really solid grasp of what negligence means legally. You know, how the law figures out who owes a duty to be careful and what level of care is expected.
Right, without all the dense legal speak.
Exactly. Just the core idea is you need to understand something that honestly affects everyone.
And we've got some genuinely surprising stuff coming up, like how a pretty grim discovery in a ginger beer bottle, like a decomposing snail, actually.
Yes, famous case.
How that completely changed modern law. And, you might think a learner driver would get some slack, right?
You would think so.
But nope. We'll look at why the law holds them to the exact same standard as an expert driver. It's quite something.
It really is.
Yeah.
And it shows how the law sometimes makes these broad choices about risk.
We'll also unpack how courts juggle different factors when deciding if someone was careless. So yeah, get ready for some moments where it just clicks. It'll definitely shift how you think about legal responsibility.
Okay, so let's start right at the beginning. Negligence. What is it? Fundamentally, it's a civil, lawyers call it a tort.
Right, a tort.
And it happens when someone's action, or sometimes their inaction, breaches a legal duty they have to take care, and that breach causes harm.
So there are steps to proving it.
Absolutely. 3 key things you usually have to show. First, that a duty of care actually existed between the parties.
Okay.
Second, that the person breached that duty, they didn't meet the standard of care required.
Got it.
And third, that the harm suffered was actually caused by that breach. And it wasn't too remote a consequence. Lawyers call that causation and remoteness.
But for this deep dive, we're really zeroing in on just the first 2.
Exactly. Duty of care and breach of duty, they're the absolute foundation.
What I find fascinating is that this whole idea of a general duty, it wasn't always there, was it? Before, say, the 1930s.
Not in the broad sense we understand it now. Judges tended to recognize liability only in very specific, established situations.
Like what?
Oh, think maybe manufacturers of inherently dangerous things, like guns, perhaps, or an innkeeper's duty to a guest. It was quite limited.
But then came 1932.
Yes. That's the watershed moment. The modern understanding of negligence really kicks off with the House of Lords decision in Donoghue v. Stevenson.
Okay, this is the snail in the bottle case.
That's the one. Still famous after all these years.
So for anyone who hasn't heard it, remind us. A woman, May Donoghue, she got sick because there was, the remains of a snail in her ginger beer.
Correct. But the crucial point was her friend had bought the drink.
So she didn't have a contract with the shop owner or the manufacturer who made the drink?
Precisely. Under the old rules, that lack of a direct contractual link was often a barrier to suing. She couldn't sue in contract.
But the court found a way.
The House of Lords did. They decided the manufacturer did owe Mrs. Donoghue a duty of care, even without a contract. And Lord Atkin's judgment is legendary. He introduced the neighbor principle.
The neighbor principle.
He basically said, look, you have to take reasonable care to avoid actions or failures to act that you could reasonably predict would likely injure your neighbor.
And neighbor here isn't just the person living next door, right?
No. In legal terms, it's anyone who is so closely and directly affected by what you do that you should reasonably have them in mind when you're acting. It was a massive shift.
Moving away from just strict contracts towards, a broader sense of responsibility to people around you.
Exactly. It introduced this idea of proximity, not just physical closeness, but closeness in terms of the relationship or the directness of the impact.
So after Donoghue, the court started recognizing more situations where this duty automatically exists.
Yes, a whole range of what we now call established duty situations developed. The obvious ones, drivers to other road users.
Employers to employees.
Doctors to patients, manufacturers to consumers, shopkeepers to customers. The list goes on.
And the law could keep adding new ones.
That's what Lord Macmillan suggested in Donoghue itself. He famously said, the categories of negligence are never closed. The law needed to adapt.
Okay, so that covers situations where the courts have already said, yes, there's a duty here. But what about totally new scenarios, something that hasn't come up before?
Well, that became the next challenge. How far do you stretch Lord Atkin's neighbor principle? There was a bit of an expansionary phase in the 70s and 80s where maybe it went quite wide.
And then they needed to refine it.
Exactly. They needed a more structured approach for these novel duty situations. And that structure arrived in 1990 with another landmark case, Caparo Industries, PLEV, Dickman.
Caparo. Okay, what did that establish?
It set out a three-stage test, specifically for deciding if a duty should be imposed in a new type of situation.
And the stages are?
First, was the harm reasonably foreseeable to the claimant? Second, was there sufficient proximity in the relationship between the claimant and defendant? And third, is it fair, just, and reasonable to impose a duty of care in these circumstances?
Let's break those down. Reasonable foresight of harm that seems fairly straightforward.
Often it is, yes. If you, say, leave a tool lying on a pavement, it's reasonably foreseeable someone might trip over it.
Like that case with the hammer and the blind person.
Exactly. The court said the duty was owed to anyone reasonably expected to use the pavement. Foreseeable victims include those with disabilities. It's about predicting the type of harm.
Okay. Then proximity. We said it's not just physical distance.
Right. It's about the closeness of the relationship in a legal sense. Is the defendant closely and directly connected to the claimant or the harmful event? This gets more complex with things like economic loss or psychiatric injury, where the link might be less direct than physical damage.
Right. Like that example on the source about the water survey abroad. Did the surveyors have enough proximity to someone who got sick later? It's tricky.
It can be. And then the third stage of Caparo, fair, just, and reasonable. This is really where broader policy considerations come in.
So even if harm was foreseeable and there was proximity, the court can still say no duty.
Yes. They might decide that imposing a duty in this type of situation would have undesirable consequences for society as a whole.
Like opening the floodgates to too many claims. Or maybe hindering the work of certain bodies.
Potentially, yes. Or think about nonprofits providing a social good. Maybe imposing a duty could threaten their viability. The courts use this stage to sometimes draw a line based on wider public policy.
So for a while, everyone thought this Caparo test was the standard approach for all duty of care questions.
That was the assumption for a time, yes. Applied the three stages. But then fairly recently, the Supreme Court clarified things significantly in Robinson v. Chief Constable of West Yorkshire Police in 2018.
Robinson? What happened there?
It involved an elderly woman, Mrs. Robinson. She was walking down the street, and some police officers in plain clothes were trying to arrest a suspected drug dealer.
Yep.
In the struggle, the officers and the suspect basically knocked Mrs. Robinson over, and she was injured.
Right. So, did the police owe her a duty?
The Supreme Court said yes, absolutely. And they found the officers had breached that duty. But the really important part was how they reached the duty conclusion.
How so?
They clarified that the full three-stage Caparo test, especially that fair, just, and reasonable part, is really only meant for truly novel cases. Situations where there's no existing law or precedent to guide the court.
Ah, okay. So if the situation fits into an existing category or is very similar to one,
then you don't necessarily need to go through the whole Caparo analysis again. You look at the established principles. Does it fall under a known duty, like someone causing direct physical harm through a positive act?
like the police did to Mrs. Robinson.
Exactly. Or can the existing principles be extended logically, by analogy, to cover this slightly new situation?
So Caparo isn't dead, it's just reserved for the genuinely new frontiers of negligence law.
That's a good way to put it. Most cases will likely be resolved by looking at existing precedent or extending it incrementally.
This seems especially relevant for public bodies, like the police or local councils. There was always a bit of reluctance to impose duties on them, wasn't there?
There was, and often still is, due to policy concerns. Things like who pays if they're found liable, usually the taxpayer. Or the worry about defensive practices, police being too scared to act decisively for fear of being sued.
That's the sort of Hill immunity idea, named after a case involving the Yorkshire Ripper.
Yes, the Hill case suggested police might have a certain immunity regarding failures in their core investigative duties. But Robinson made it clear, while there might be immunity for some failures to prevent crime by others, police are liable for the reasonably foreseeable consequences of their own positive actions that directly cause harm during their operations.
So it's about what they do rather than just what they fail to prevent.
Broadly speaking, yes, it draws a line between operational negligence causing direct harm and policy decisions or failures to confer a benefit.
Okay, one last point on duty before we move to breach. What about not doing something? Omissions.
Ah, yes. The general rule in English law is quite harsh, actually. There's usually no legal duty to rescue someone or prevent harm, even if it would be easy to do so.
So if I see someone walking towards a cliff edge, legally, I don't have to shout a warning.
Legally, generally no.
Yeah.
Morally, of course, it's different. The law doesn't impose a duty unless there's a specific reason, like a pre-existing special relationship.
Parent and child, doctor and patient.
Exactly. Or if you created the dangerous situation yourself, or if you've assumed responsibility for someone. But just being a bystander, usually no duty to intervene.
Like that case where the council didn't remove an earth bank blocking the view at a junction?
Right. An accident happened later, but the court said the council had no positive duty to improve visibility or remove a natural hazard they hadn't created. No duty for the omission.
But there are exceptions.
There are. Control is a key factor, like the case with the Borstal boys, the prison officers supervising them.
Ah, where the unsupervised trainees damaged someone's yacht.
Yes. The officer's employer was held liable because the officers had control over the trainees and failed to exercise it, leading to foreseeable damage. So, control over the person causing harm can create a duty related to an omission, a failure to control.
Okay, that makes sense. So hurdle 1 is establishing that a duty of care was actually owed. Tricky stuff sometimes.
Definitely.
But let's say we've established that, yes, the defendant owed the claimant a duty. What's next?
Hurdle 2.
Mm-hmm.
Proving the defendant breached that duty. They fell short of the standard of care the law required of them.
And how do courts figure that out?
It's essentially a two-part question. First, a factual one. What did the defendant actually do or not do? And second, the legal question. How should they have acted? What was the required standard of care in those specific circumstances?
Okay, so you have to show fault.
Precisely. Negligence liability isn't automatic just because someone got hurt. You have to show the defendant failed to act as carefully as the law demands. And the key test here is objective.
Objective, meaning it doesn't matter what the defendant was thinking or if they were trying their best.
Largely no. The standard isn't subjective. Did this person do their personal best? It's objective. How would a reasonable person have acted in the defendant's position?
The reasonable person, we hear that phrase a lot.
It's central. This standard comes from a very old case, Blyth v. Birmingham Waterworks, and it's about judging conduct against the societal expectation of reasonable care, not against perfection, but against a certain baseline.
So it's not about finding blame in a moral sense necessarily, but about whether their conduct met this legal benchmark.
Exactly. Did their actions fall below the standard expected of this hypothetical reasonable person?
And who is this reasonable person? Is it just average?
Courts have described them in various ways. The old phrase was the man on the Clapham omnibus. Just an ordinary person. Think of your average prudent neighbor, someone who exercises ordinary reasonable caution. Not overly cautious, not reckless.
Just reasonable, though I guess what's reasonable can be debated.
Oh, absolutely. And who applies the standard? Judges. So there's always a discussion about how objective it truly is, especially in reflecting the diversity of society. But the aim is objectivity.
And this standard applies even if someone genuinely lacks the skill, like our learner driver example.
Yes. This is where the law can seem quite strict. Saying I'm inexperienced or I'm just not very good at this is generally not an excuse for falling below the reasonable standard.
So the learner driver who caused the accident
is judged against the standard of a reasonably competent and experienced driver. No allowance was made for her being a learner.
Why is the law so tough on that?
Policy reasons, mainly. Primarily the existence of compulsory insurance. The courts reason that the injured person needs compensation, and insurance provides the mechanism for that. Holding learners to the experience standard ensures the risk is broadly spread via insurance, rather than the victim bearing the loss because the driver was inexperienced.
Okay, that makes it kind of societal sense, even if it feels harsh individually. Does this apply to professionals too, like a junior doctor?
Yes. If someone is holding themselves out as having a particular skill or role, they're judged by the standard expected of a reasonably competent person in that role. So a junior doctor, filling a more senior post, is judged by the standard of that senior post.
Not just a reasonable junior doctor.
No. The public expects a certain standard from the post, regardless of the individual's personal experience level within it at that moment.
But what about children? Surely they aren't held to the standard of a reasonable adult.
Correct. Here, the standard is adjusted. It remains objective, but it becomes the standard of a reasonable child of the defendant's age.
Ah, okay. Like those cases mentioned, the schoolgirls playing with rulers.
Yes. 2 15-year-olds. One got injured. They were judged by the standard of reasonable 15-year-olds engaging in that kind of horseplay, not reasonable adults. Same for the 13-year-old playing tag. What would a reasonable 13-year-old foresee?
That seems fair. Now, what about people with special skills? Doctors, electricians, accountants.
They aren't judged by the man on the Clapham omnibus. They're judged by the standard of the ordinary skilled person exercising and professing to have that special skill. This is often called the Bolam test.
The Bolam test. So, not the best expert in the field, but a competent professional.
Exactly. The standard is that of the ordinary competent practitioner in that particular art or profession. You don't have to be a genius, just reasonably skilled and careful according to the standards of your peers.
But doesn't that risk letting a profession set its own potentially low standards?
That was a concern raised about Bolton, especially in medicine. Could doctors escape liability just by finding some colleagues who agreed with their practice, even if it seemed illogical?
So, was it clarified?
Yes, significantly, by the Bolitho case. The court said that while professional opinion is important evidence of the standard, the court ultimately decides a medical practice won't be considered reasonable just because some doctors follow it if the court itself finds that practice to be illogical or lacking a rational basis.
So, the court retains the final say on what's reasonable, even for professionals.
Absolutely. Professional standards are influential, but not automatically decisive if they don't withstand logical scrutiny.
Okay. So, when deciding if the standard was breached, the court looks at this reasonable person or reasonable professional standard, but how do they apply it? You mentioned a balancing act.
Yes. Once you know the standard, you have to see if the defendant's actions fell below it. And courts weigh up several factors in doing this. It's not a simple tick box exercise.
What kind of factors?
One key factor is the likelihood of the harm occurring. How probable was it that someone would get injured by the defendant's actions?
Right. So, a really tiny freak chance of harm might mean no breach, even if harm did happen.
Potentially. Think of that cricket ball case, Bolton v. Stone. Balls hit out of the ground very rarely, like 6 times in decades. The House of Lords said the likelihood was so small, the club hadn't breached its duty by not taking extraordinary precautions, like building a massive fence.
But compare that to the other cricket case, Miller v. Jackson.
Where balls were flying into gardens multiple times every season. The likelihood there was much higher, making a breach far more probable. It's about reasonable foreseeability turning into significant probability.
Okay, likelihood. What else?
The seriousness or degree of the potential harm. Even if the risk is small, if the potential injury is catastrophic, the law expects greater care.
That makes sense. Like the case with the one-eyed worker, Paris v. Stepney.
Exactly. The risk of any eye injury from flying metal might have been the same for all workers, but for a man already blind in one eye, the consequence of that injury, total blindness, was far more severe. So the employer should have taken greater care, like providing goggles, specifically for him. His known vulnerability mattered.
So likelihood and seriousness are weighed up. What else?
The cost and practicality of taking precautions. How easy or difficult or expensive would it have been to eliminate or reduce the risk?
So if a simple, cheap fix was available, not using it looks bad.
Generally, yes. But if the only way to prevent the risk involves huge expense or effort, disproportionate to the risk itself, the court might find it was reasonable not to take those steps.
Like the flooded factory case. Latimer.
Right. Slippery floor after a flood. They put down sawdust but couldn't cover every single patch of oil. A worker slipped on an untreated bit. The court said the factory had done what was reasonable. Closing the entire factory, the only way to guarantee safety, would have been too drastic and costly given the situation.
It's about proportionality.
Precisely. And finally, courts sometimes consider the social value or utility of the defendant's activity.
How does that fit in?
Well, if the activity carries some benefit to society, think emergency services responding to a call, or even just the general benefit of playing sports, the court might be slightly less demanding about the standard of care required, acknowledging the inherent risks in valuable activities. It doesn't excuse negligence, but it's part of the balance.
So it's this complex weighing of likelihood, seriousness, cost of precautions, and maybe social value.
Yes, all balanced against each other to decide if the defendant acted unreasonably if they breached the duty of care owed.
Okay, that paints a much clearer picture of how breach is determined.
Oh, well, that brings us towards the end of this particular deep dive. We've really journeyed through the core of negligence, haven't we? Focusing on that duty of care and the breach.
We definitely have. We saw how it all arguably kicked off in earnest with that snail in the bottle.
Donoghue v. Stevenson, 1932. Establishing the neighbor principle. absolutely fundamental.
And then how the courts figured out when this duty applies, moving from established situations through the Caparo test for novel scenarios.
And then the refinement with Robinson, clarifying that Caparo is mainly for the truly new stuff, while most cases rely on existing precedent or analogy.
We looked at the standard of care itself, that objective, reasonable person test.
Yeah, and how that standard gets applied differently, or rather the reasonable person benchmark shifts, depending on whether we're talking about children or skilled professionals, but generally holds firm even for learners.
And finally, that crucial balancing act the courts perform when assessing breach, looking at the risk, the potential harm, the practicality of preventing it, and even the social utility.
Exactly, weighing those factors, likelihood, severity, precautions, social value.
So you should now have a really solid framework for understanding these first two absolutely critical elements of any negligence claim. They underpin so much of how our legal system deals with accidents and compensation.
They really do.
Okay, so to leave you with something to think about, we've talked a lot about the reasonable person standard aiming for objectivity. But if, at the end of the day, the definition of what's reasonable is shaped by the judges applying it, who come with their own experiences and perspectives, how truly objective can that standard ever be?
Mm?
And what might that mean for achieving justice in a world that's increasingly diverse and complex? Something to mull over.